Jimerson and Cobb is a business litigation firm located in Jacksonville, Florida. Thank you for choosing to watch our presentation on injunctive relief. We'll cover the topic of injunctive relief according to the overview on your screen. We'll start with pre-litigation considerations. We'll look at how you obtain injunctions, what the injunction order looks like, bonding requirements, wrongfully issued injunctions and damages therefrom, dissolving and modifying injunctions, how do you enforce an injunction, and finally, certain context where injunctions are appropriate. To start with the basics, what is an injunction? An injunction is a discretionary, equitable remedy. Therefore, it's not a question for the jury. It's primarily preventative in nature. So you don't use an injunction to correct wrongs already done. You don't use injunctions to restore to a party certain rights which have already been deprived. Injunctions look to the future and prevent future acts. They're designed to protect one from irreparable injury by commanding acts to be done or prohibiting certain acts from occurring. The purpose is to preserve an existing state or condition. This is often called the status quo, and the purpose is to afford relief against future acts. Pre-litigation considerations. So what should you think about when deciding whether to pursue an injunction? First, whether you should sue for injunction at all, or is there some other remedy that may suffice? What type of injunction should you request? Who should you sue? Where do you sue? When do you sue? Some other considerations to think about. And finally, a list of what you should prepare before your first temporary injunction hearing. Deciding whether to sue for an injunction is a very important decision. An injunction is unlike most other remedies you may seek. For instance, it can disrupt your client's business. Their immediate expenditures, both in time and money, to your client and to your firm. There's a significant risk in seeking a temporary injunction, and that the court's decision on whether to order the temporary injunction can effectively end the case. In many cases, if you are successful and you get the temporary injunction, case closed, you win. On the other hand, if you lose, it gives the defendant great leverage and psychological advantage in settlement negotiations. Some factors to consider. You look at the possibility of success. Would you have a better chance of accomplishing your client's goals if you were to seek some other type of relief, such as a declaratory decree? How long will the injunction be effective, both practically and legally speaking? What are the impacts on third parties, and what are the impacts on the employees of your client? There's the possibility of disclosure of confidential information and trade secrets. And lastly, the effect on the plaintiff's public image for bringing the injunction lawsuit, for settling the suit, or losing it. Once you've decided to sue for injunction, you need to carefully consider how you're going to craft your request. To start, you need to define your client's aims and goals and determine how best to accomplish them in structuring the request for injunctive relief. And then you balance that out with the chances of success. How you craft the request can affect your chances of request. For instance, if you're requesting broad relief, you may be less likely to be awarded the injunction than if you tailor your request to limited relief. The courts avoid granting broad requests, whereas more limited requests are more likely to be granted. You also should consider that temporary injunctions must preserve the status quo. So you tailor your request to specifically preserve the status quo. And the status quo is defined by Florida case law as the last peaceable, non-contested condition that preceded the controversy. You also here consider that the most compelling reason in favor of granting an injunction is the need to prevent the judicial process from being rendered futile by the defendant's action or refusal to act. You should decide if you would like a prohibitory or mandatory injunction. Courts prefer prohibitory. A prohibitory injunction is one that restrains the enjoined from taking certain actions, whereas the mandatory injunction coerces certain actions. And a mandatory injunction is going to add an additional burden of proof upon the plaintiff, which is, the plaintiff must prove that his right to the mandatory type injunction is clear and free from reasonable doubt. Also consider the practicability of the court's ability to enforce the injunction. Courts avoid injunctions, if they can, that require the court to spend valuable court time supervising and intervening the injunction. And this kind of dovetails back into the prohibitory versus mandatory question. A mandatory injunction oftentimes requires more court supervision. Be very certain to avoid vagueness in crafting your request, and then in crafting the order itself. Vague injunctions are not enforceable by contempt. The enjoined party must be held to have known what was required of the party to comply with the injunction before that party may be held in contempt for failure to take or not take that action. In other words, a vague injunction is not enforceable by contempt. Lastly, for this slide, temporary injunction may be the best solution, or instead you may avoid moving for temporary injunction and pushing quickly for the final permanent injunction. In most cases, the temporary or preliminary injunction will be the best course of action. Who should you sue? Well, the issue here is who do you need to be bound by the injunction? Florida Rules of Civil Procedure 1.610C tells us who's bound, and that includes the parties to the action, the defendants, their officers, agents, servants, employees, and attorneys, and those persons in active concert or participation with them who receive actual notice of the injunction. It is somewhat ambiguous who is referred to in that third leg of the statute. It can be challenged or argued, and therefore the best solution to that problem is to just name as a defendant any and all persons or entities who you would like to be enjoined. Where should you sue? Like in all litigation, the home court advantage is something to consider. Here in an injunction litigation, it's probably of greater importance. The home office advantage, suing in a venue close to your office can be important, especially because the injunction litigation starts at full speed right out of the gate and continues to run at full speed through the determination of the injunction. In usual injunction cases, you're going to be working 24 hours a day until you get the injunction. Also, you should consider filing in a federal versus a state court, assuming that you have that option, assuming that you can get jurisdiction in both courts. There's different injunction procedures. For instance, As listed on the slide, the federal courts and Florida courts differ when it comes to the temporary restraining order, which is what it's called in the federal courts, the TRO, and it's called the same thing. It's called a temporary or preliminary injunction in Florida. The federal TRO automatically expires 10 days after it's ordered, whereas the Florida temporary injunction remains in effect until further order of the court, meaning until someone moves to have it dissolved. When should you bring the action? Well, the temporary injunction needs to be brought at just the right time. You don't want to bring it too early or too late. Too early, the case basically isn't ripe yet. One of the elements of an injunction is irreparable harm, and such harm needs to be reasonably imminent. If there's a question of, a substantial question of whether the irreparable harm could or cannot occur yet, it may be too early. It'll be too late if the status quo has already been destroyed. If the harm that you're seeking to enjoin has already occurred, it may have destroyed the status quo that you were looking to maintain. In other words, the case will be moot. The permanent injunction is subject to latches. Basically, you just don't want to delay while the other party that you're seeking to enjoin entrenches into a position from which he cannot extricate himself without great injury. Some other considerations, your expert witness selection, that needs to happen at the outset, pre-litigation. The expert, there may be a small number of suitable experts in your market region. You want to make sure that you lock up the best expert before the other parties do. The expert may be useful in general consultations concerning discovery and strategy, and specifically to injunction litigation at a temporary injunction hearing, which will normally be disputed. There will be an evidentiary hearing, and your expert witness will be a key witness at that hearing. Expedited discovery can oftentimes be involved in an injunction litigation. One party or the other can move for expedited discovery. You can move for expedited discovery at the outset, and courts will normally grant that. Therefore, you need to be prepared for expedited discovery before you file suit. Here's a list of what you should prepare before the temporary injunction hearing. And keep in mind that the temporary injunction hearing, if you're, like oftentimes, if you want an ex parte hearing, a hearing without notice, all of these items you may need to have all these items the day you file suit. So we start with the complaint, and it's highly recommended that you verify the complaint. You can't move for temporary injunction without having underlying causes of actions already stated, and those would be stated in the complaint. Some jurisdictions require you to file a motion for injunctive relief, while other jurisdictions may allow a properly pled complaint to serve as a request for temporary injunction. You'll need affidavits in support of your request. For instance, you'll need the counsel's affidavit regarding the need for ex parte relief. That doesn't necessarily have to be an affidavit form. It could be in a written certification. You'll want a memorandum of law explaining to the court your grounds for the injunction and possibly your reasoning for ex parte lack of notice. Your proposed order, you'll want that signed at the hearing, so bring that with you. We'll talk about orders in a little more detail later in the presentation, but for now, just we need to know that the order is very important, how it's written. It needs to be very clear, while at the same time it needs to fully encompass whatever activities or assets you want to enjoin. Be prepared to pay the bond or have a surety lined up. If you desire expedited discovery, you should have your motion there, including any of your discovery documents that you would like to propound. Obtaining injunctive relief. So we've moved past the first section of the presentation. Now we're moving into how do we get an injunction. We'll first look at the elements that we need to prove. Then we'll look at the particulars of ex parte relief, and then we'll look at hearings generally. Lastly, we'll look at the effect that findings of fact and conclusion of law have on the rest of the case, including trial. First, it's important to point out and for you to understand that the issuance of a preliminary injunction is an extraordinary remedy, and courts will grant it sparingly. There are 4 elements, and the first is irreparable harm. A plaintiff must prove that irreparable harm will follow unless the injunction is issued. The question then becomes, what is irreparable harm? And it's harm of such nature that it cannot be redressed in a court of law. For instance, an injury for which monetary compensation will not suffice. Irreparable harm and the requirement of an inadequate remedy at law are closely aligned and sometimes overlap, meaning there are some courts that speak of just one element, that is a combination of the irreparable harm element and the inadequate remedy at law element. A plaintiff lacks an adequate remedy at law where he could not obtain a judgment in a proceeding at law. So it's not a ability, or it's not a produce money test. It's not whether the judgment would procure pecuniary compensation. The uncertainty of collectability is not the rule. It's the whether or not you could get a judgment. Impossibility of ascertaining the amount could be an inadequate remedy at law. Injunctive relief is not precluded by existence of a liquidated damage provision in an agreement. So we've discussed irreparable harm, inadequate legal remedy. Now we look at the third element, clear legal right to the requested relief. A contingent, unproven, and disputed claim for money damages is not sufficient to satisfy the clear legal right or interest requirement. A different way to think about this element, and the way the federal courts call it, is a substantial likelihood of success on the merits. So you prove to the court that your underlying cause of action is likely to succeed. And that is a clear legal right. Some would say that public interest is a fourth element. Courts will look to ensure that the public interest favors the issuance of an injunction. And lastly, the courts will balance the equities. They'll examine the threatened injury to the plaintiff, and they'll compare that to any possible harm to the person that the plaintiff is looking to enjoin. Ex parte relief, which is obtaining a temporary injunction without noticing or attempting to notice but achieving no response from the adverse party. Florida rules of civil procedure guide us here and tell us what's required. So we must show that the specific facts of the verified complaint or affidavits show that an immediate and irreparable injury, loss, or damage will result to the movement before the adverse party can be heard in opposition. So, in other words, we will be harmed if we wait for the other party to show up at the hearing. If we give him, for instance, a 7-day notice, that in the intervening time that the movement will suffer irreparable harm. But then we also need to have a certified writing by the movement's attorney attesting to the efforts that have been made to provide notice and the reasons why notice is not required. Alternatively, subpart B may not be necessary if there's good reasons not to give notice, and those good reasons are found in the verified allegations of the complaint. So if there's good reasons for not giving notice, the court may issue ex parte temporary injunction without the attorney having to certify in writing the efforts made. On this slide, it's also important to note that under Rule 1.610A2, that no evidence other than the affidavit or the verified pleading shall be used to support the application for a temporary injunction unless the adverse party appears at the hearing or has received reasonable notice of the hearing. Well, what this means really is that ex parte hearings aren't really a hearing. You do not put on any evidence or make any arguments. You basically hand your pleadings to the judge and ask him to sign your order. Continuing on with the ex parte relief issues, under Rule 1.610A2, every temporary injunction granted without notice, so they are ex parte injunctions, require the items listed on the slide. Failure to comply with this rule is reversible error. However, you'll often find that the courts fail to put the date and the time on the order, and at least one case is held that that's fine. That's not reversible error. The last two bullet points on this slide cover a topic we've already covered. It examines the differences between state and federal court and the timing and duration of the injunctions. Injunctions can only be granted upon a verified complaint or a verified motion, as we talked about before, and in some circumstances, affidavits or live testimony may be required. Those would be required when an evidentiary hearing is required, which occurs when there's any material facts that are contested. So we're looking at here a noticed hearing. You moved for an ex parte hearing, and the court disapproved, didn't grant you the ex parte injunction, and told you to provide notice. And then you gave 7-day notice to the adverse party, and they respond and they contest certain facts. An evidentiary hearing will be required at that point. You'll both put on witnesses. How much notice is required that's a question that some courts differ in the answer. There's been at least one case where 1 to 3 days, even if over the weekend, was sufficient notice. We also have another case where 7 days was sufficient notice. I think you'll find that 7 days notice is fairly common. Evidence that a court can rely on. They can rely on evidence from earlier hearings. They can rely on evidence, and that actually, the evidence from earlier hearings may depend on the type of hearing that you're at. Also, evidence presented at that hearing, and then importantly, hearsay evidence may be relied on. It's not a matter of all hearsay evidence is always permissible, but the court has the discretion to weigh the factors and determine whether at the preliminary hearings for the injunction, the court may make findings of fact and law, and the question then becomes, what are the effects of those findings? And the answer is, those findings are not binding at the trial. The reason is there are specific rules for drafting an injunction order. Florida Rule of Civil Procedure 1.610C provides the guidelines that must be followed. They must specify the reasons for entry of the injunction, which means that the order must provide clear, definite, and unequivocally sufficient factual findings regarding the elements of injunctive relief. And then also, and sometimes more importantly, the order must describe in reasonable detail the act or acts restrained without reference to a pleading or another document. So you can't incorporate the request from the complaint. The face of the order must state the acts to be enjoined. And here we tie this back into the vagueness consideration. You do not want to skimp on this part of the order. You want to spend some time to make sure your language is very clear. If it's not clear, the judge will not issue the order. Also, if it is not clear, if it's arguably vague, the order may not be enforceable. Scope of the order. Prior to 1982 in Florida, perpetual injunctions were not enforceable. Since 1982, they may be perpetual, but mandatory injunctions may not be perpetual. So we're talking about prohibitory injunctions can be perpetual. And the geographic scope of injunction orders is quite broad. It's not limited to the jurisdiction granting the order. It can be anywhere in the country or even outside the country. Bonds are required for injunction orders. The injunction order will not be effective until the bond is posted. There's two exceptions for when a bond is required, provided in the Florida Rules of Civil Procedure. They're on your slide. It's when the bond is, when the order is issued on the pleading of a government entity, or when the injunction is to prevent physical injury. And many times you'll see a contract that limits or waives the bond requirement. The courts will not really give that any effect. The court will still require the bond if the enjoined party will sustain damages for a wrongful injunction, which is the case in almost all cases. The dollar amount to the bond is determined by the court in its discretion, and the amount is determined to pay the cost and damages sustained by the adverse party if the injunction is wrongful. So at a minimum, it should be the adverse party's attorney's fees in getting the injunction dissolved. It'll include any other reasonable damages that could be expected as part of that wrongful injunction. Staying with the topic of wrongful injunctions, the harmed party is limited in its damages that it can be awarded, and it's limited to the bond amount, unless first there's no bond. If there's no bond, then they can seek damages of any amount. If the injunction was obtained maliciously or in bad faith, the damages then can exceed the bond amount. And if there was an ex parte injunction and the enjoined party proceeded expeditiously to exhaust available remedies, then that harmed party can be awarded damages in excess of the bond amount. Attorney's fees are awarded in any event, but limited to the dissolving of the injunction. A party, or even a non-party, may seek dissolution or modification of the injunction, and pursuant to the rules of civil procedure, they do so by motion, and upon applying for a hearing on the motion, the hearing must be held within 5 days. The burden is initially shifted. The plaintiff has the initial burden, even though the defendant is the movant. So the plaintiff's burden is simply to reprove the injunction, which can be a rather simple task. You can make the argument to the court that I just proved my right to the injunction last week in front of you, Your Honor. There is a question of what evidence is available after the initial hearing. The 5th DCA has held that any evidence that was or could have been offered at the initial temporary injunction hearing cannot be a basis of a motion to dissolve. That the motion to dissolve or modified must be based on the evidence of a change in conditions occurring after the entry of the temporary injunction. On the other hand, the 4th DCA has not taken that stance, and any evidence at the initial hearing may be offered and may be the basis for a motion to dissolve. Once you have your injunction order, how do you enforce it? You enforce it by contempt. The enjoined party who violates the injunction can be punished with civil contempt or criminal contempt and or compensatory fine. Now let's look at some specific context where injunctions are appropriate or allowed. Covenants not to compete are a fairly common context for injunctions. First, bonds are required, and we say that here because you may find in the non-compete agreement language waiving or limiting the bond. Courts do not give that effect. Bonds are still required by statute. The same for attorney's fees and costs. Contracts waiving or limiting such fees are not given effect. Pursuant to statute, attorney's fees will be awarded. An injunction may not be ordered if the employer has breached the agreement. For instance, if an employee is violating his non-compete but is still owed money by the employer may not enjoin the employee from violating the non-compete. However, recent case law tells us that an independent covenant not to compete, independent from the employment agreement, may provide the employer the ability to enjoin the employee. So we looked for independence of the non-compete agreement from the employment agreement. Liquidated damages in a non-compete agreement may not prevent equitable injunctive relief. You may think that liquidated damages allow for an adequate remedy at law, which would prevent an injunction from being ordered. One of the elements of an injunction is the inadequacy of the remedy at law, and here liquidated damages are an express adequacy of the remedy at law. However, the LDs, the liquidated damages, would be applied towards past acts, prior violations of the non-compete, whereas the injunction could apply to and enjoin future acts, future violations of the non-compete. An injunction may be precluded when the defendant terminates the offending activity prior to or even after the action is commenced. Lastly, and interestingly, final judgment may extend the restrictive time period. For instance, the second, third, fourth DCA have cases that have held and have ordered the full duration of the non-compete to commence on the date of the final judgment order. Whereas the fifth DCA have generally held that you cannot extend past the contract term dates. What we mean here is, for instance, a three-year non-compete that you would think commences upon the execution of that agreement or the termination of an employee, and then a year later the employer files suit to enjoin. The case takes 6 months to get to completion, at which time the final judgment is ordered a year and a half into the term dates. You would think that there would be only a year and a half left on that judgment, that the judgment could only name another year and a half for the injunction time period. That's how the fifth DCA would hold. The other courts, at least the second, third, and fourth DCA, may hold differently and would have the full 3 years be enjoined starting from the date of the final judgment order. Tortious interference is another cause of action where an injunction may be available. An injunction would be available, for instance, to enjoin a competitor's interference with an exclusive franchise. An injunction may be available where there's interference with potential customers. Even where there's no non-compete agreement, a former employee who's soliciting the employer's customers may be enjoined. Likewise, a former employee who, again, is not under a non-compete agreement may be enjoined from using a customer list that he took from the employer. And use of trade secrets can be enjoined in the absence of a non-compete agreement. In the breach of contract context, injunctions will be very rare. Here, an injunction is equivalent to specific performance. And a movement looking for an injunction in a breach of contract is going to be held to the same strict standards of specific performance, including the specificity of terms and the mutuality of remedy. Of course, contracts for personal services will never be subject of injunctive relief, except in the case of non-compete agreements. In the corporation context, injunctions may be available. Specifically, an injunction may be available to prevent an officer or a director from breaching his or her fiduciary duty. This is particularly true when in the context of self-dealing or in the infringement on shareholder voting rights. Also, in the context of corporate dissolutions, specifically to preserve corporate assets, where there's deadlock or misappropriation of corporate assets that harm the dissolution. Irrevocable letters of credit. Banks may be enjoined from dishonoring drafts against the irrevocable letter of credit, but only if the underlying transaction is wrought with fundamental or egregious fraud. There is a case that is held that non-conforming documents will suffice to allow injunctive relief. Promissory notes. Injunction is not typically available to enjoin the dissipation of assets. The reason why is because typically there will be an adequate legal remedy in a money judgment. And the test of inadequacy of the remedy at law is whether a judgment can be obtained and not whether once obtained it'll be collectible. So while you may wish to enjoin dissipation of assets by the debtor, knowing that without the injunction there may be no collectible assets remaining when you get your money judgment, it's still that is not an argument that a court will order an injunction. In the context of trusts, you may be successful in obtaining an injunction to freeze trust assets. For example, trust funds held for children of the decedent, where numerous people come forward claiming to be children of the decedent. The bank may be enjoined from distributing any funds until the court can determine who is to receive the money. Also, you may enjoin a trustee to act in his fiduciary or representative duty. Continuing trespass is a common context for injunction. It is available against the state as well as against individuals. However, you cannot enjoin conduct that has been allowed to continue for so long that the harm to the party enjoined would outweigh the harm to the party seeking the injunction if no injunction were issued. You may also want to consider here as an alternative route Florida's littering statute, which provides for attorney's fees. Injunctions are available for trademark infringement under Florida statute. For instance, to prevent dilution of the mark or the trade name, label, or form of advertisement. Also for injury to business reputation. Injunctions are available for common law unfair competition. The Florida Rico Act provides injunctive relief for racketeering activities that are prohibited by the Act. You can even freeze assets that are proceeds of racketeering. Florida's Little FTC Act provides for injunctive relief for violations of the Act for deceptive and unfair trade practices. Also, Florida statutes appear to grant standing to any person, not just consumers, to seek an injunction for deceptive and unfair trade practices. The Federal Digital Millennium Copyright Act provides for injunctive relief against acts that violate the DMCA. There are other miscellaneous actions that Florida statutes specifically allow injunctive relief. For instance, the abatement of public nuisance, actions to quiet title, tenant misuse of property upon proper notice. You can enjoin the unauthorized commercial use of your likeness or name. Continuing on in Florida statute, combinations restricting trade or commerce can be enjoined. Statutory violations by the seller of a business opportunity. can be enjoined. Injunctive relief is available in appropriate situations to creditors whose debtor is owner of security to satisfy a judgment or claim. In the condominium association context, and also in the the homeowner association context under Florida Statute 720, the association or a unit owner may enjoin statutory violations. Also can force compliance with the DECs, the condominium declarations, or charter or bylaws. And attorney fees are available to prevailing party. Lastly, a creditor may enjoin fraudulent transfers under Florida's Fraudulent Transfer Act. Thank you for joining us today in our presentation on injunctive relief. If you have any questions or would like to discuss any of the content with us, please feel free to contact us at any time, or for any other matters that you may have, feel free to contact Jimerson and Cobb. Thank you. Have a great day.